the Implementing AB5 Employees or Contractors webinar. I'm Lucy Salcido-Carter, Policy Director at Cal Nonprofits, and one of your moderators for today. We have a couple of great presenters with opportunities for you to ask some questions too. This webinar is the third in a series of 4 legal do's and don'ts webinars that we are doing in partnership with Public Counsel. I give a quick and heartfelt thank you to our series sponsor, Software Simplified. And I also want to let you all know that we are recording the webinar today, and a link to the recording and to the slide presentation will be available to you and mailed to you in the next couple of days. So with that, I want to introduce 2 of my colleagues who will make some opening comments and introduce our pro bono attorney presenters. A quick reminder before I do those introductions, this webinar goes until 12:15 to allow plenty of time for content and for questions. So first I want to introduce Jan Masaoka, a nationally recognized nonprofit expert and CEO of Cal Nonprofits. And secondly, I want to introduce Annie Marquette, Senior Staff Attorney in the Community Development Division of Public Counsel and my co-moderator today. So Jan, I'm going to turn it over to you and then it'll go over to Annie.
Thanks, Lucy, and thanks everybody for putting who you are and where you are in the state. I think one of the reasons why we've been so happy to partner with Public Counsel on this is that together we're able to reach nonprofits throughout the state, which is actually, of course, now that we all know how to use Zoom, a big benefit that we're all taking advantage of. I want to say a couple things as the token non-lawyer on this webinar. I said there's some things that maybe not lawyers would never say, but I'm the only person that could say them today. But they might sound a little contradictory to each other, but I want to just make them as kind of framing remarks. So first of all, in our personal lives, we don't always follow the law. For example, any lawyer would tell you, do not drive over 65 miles an hour. But many of us, I have to say, choose to do that occasionally, some of us more than others. And we have not gotten a ticket every single time we have done that. So there is a law, but on occasion, some of us, knowing the risks, will choose not to follow that law. But things are different when we're working when we're kind of acting on behalf of our nonprofit, right? So instead of a speeding ticket or traffic school, we could be actually putting our nonprofit's finances at risk. So if there's a different penalty involved, that changes the risk assessment. The potential consequence is a lot bigger than a speeding ticket, and it affects not only us as individuals, but it affects our organizations. So we have some experience with how to understand risks and laws. But it's a little bit different when we're talking about our organizations. Now, I don't mean to say that it's okay always to drive over 65 miles an hour, and it's never okay to miss a single I or crossing a single T when it comes to employment law. It does mean that you have to weigh the risks differently than you do. You have to make a judgment call. It's not kind of an algorithm that you have to put things through. It is, in fact, a judgment call, and that's why there are people involved and not just machines. So the second thing I wanted to say is that when I was writing a book on HR for nonprofit organizations, it was reinforced to me 1,000-fold how much nonprofits feel pulled in 2 different directions. So on one hand, we want to pay people well. Okay, we know that nonprofit jobs are legitimate jobs, that people support families on nonprofit jobs, and we are all committed to fair and reasonable pay. I think all of you know that Cal Nonprofits, along with our membership, we're strong supporters in increases in the minimum wage, for example, here in California. We also know that employee versus contractor laws have been very widely abused in the for-profit sector, particularly in areas like fast food warehousing and nursing homes, abusing these laws has exploited low-wage workers and deprived them of health benefits and Social Security. So on one hand, we feel very much committed to paying people fair and reasonable wages, and at the same time, we understand that that's going to affect the amount of services that we provide. And that is a tension that's just going to be there, and no amount of discussion is going to make it go away. But I do want to say that we need to acknowledge it and understand that it is also a judgment call in how we think about it. And then on the third hand, which is sort of, okay, not third hand, but you know what I mean. All right. So some nonprofit staff, such as bookkeepers, actors, dancers, preschool substitute teachers, and others, want to be paid as contractors, not as employees. And we want to be able to accommodate them. Sometimes, in fact, two people doing the same exact work, one of them will want to be paid as a contractor because that makes things work out for them better in terms of their taxes. Another person wants to be paid as an employee because they want health benefits and they want to be able to set aside some money in Social Security. So these kind of create all these different conflicts, what the person themselves wants, what our services mean, and our desire for fair and reasonable pay. All these things kind of create conflicts in our hearts. And what we have to do is just acknowledge them. And so so that's kind of a setting for understanding this. And then lastly, I wanted to kind of tell you kind of our motto when it comes to regulations. And it's kind of an all-purpose motto for this regulation, not just for this regulation. And that is this: it says 3 parts. Number 1, understand it. Number 2, comply with it. And number 3, if necessary, fight it. So with that, I turn you over to all the legal folks. And I'm going to go off camera, but I can hardly wait to hear this because I know this is a complicated but really important piece of work. So thanks very much, Lucy and Annie. And Annie, I think you're the next person, so I'm handing it off to you.
Okay, thank you so much, Jan. You set that up beautifully. You really laid the foundation and the context for what we're going to be talking about today perfectly. I'm going to talk briefly about public counsel. For those of you who are not familiar, public counsel, we provide free legal services to people in need in LA County in a number of different areas. Veterans benefits, impact litigation, children's rights, immigration. And I am an attorney in the Community Development Project, and we provide free non-litigation legal services to nonprofits that help low-income people in LA County, as well as to small businesses owned by low-income people. And so what that means is anything not related to a dispute. We do advise on employment law, we do tax exempt applications, reviewing bylaws, reviewing contracts, mergers, advice on unrelated business income. And we do these, we take on these matters both with our in-house attorneys as well as with pro bonos from firms across the county, state, and even country. And I'm going to talk a little bit about our website. In addition to our legal services, we also have resources available on our website. Our website is www.publiccounsel.org, and under practice areas, you would click on community development, and then you would go to the publications tab, and that's where you can see our sample articles of incorporation, bylaws, conflict of interest policy, whistleblower policy. We have FAQs on intellectual property, and we have a whole publication on legal issues with volunteers. I mean, there's scores of resources there. We encourage you to take a look. And in addition to our publications, we also do these trainings, both ourselves and with various partners. And I'm so excited to introduce Melinda Reichert and Jennifer Zargaroff. They're both longtime volunteers with public counsel. They're both partners at the law firm Morgan, Lewis & Bockius. They represent employers in a broad range of employment disputes, class actions, and single plaintiffs. Areas of expertise include wrongful termination, discrimination, retaliation, and wage and hour. Melinda has won verdicts for clients in both jury trials and bench trials and counsels clients on litigation avoidance strategies. Jennifer also has both trial and appellate experience and advises employers on labor and employment issues, including personnel policies, employee discipline, and employee contracts. And both are frequent speakers on employment law topics and volunteers with public counsel. As you'll see, they are excellent presenters, and I think it's going to be a really informative and useful training. Let's go to the next slide.
That's it, Annie.
Okay.
I think we're now ready for their presentation.
Can you see my screen?
Not yet.
Okay, let's try again. How about that?
Yes. Thank you.
Okay, so my name is Melinda Reichert, and I am going to talk about a very, 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 very complicated subject and try and tell you what you need to know in an hour, which is almost impossible. So let's start at the beginning and see if we can help you navigate this very complicated area. So you may have heard of AB 5, the law that was passed in September of 2019, that could potentially reclassify 2 million people in California from independent contractor to employee. That's 10% of the workforce of the state. That's a lot of people. And so you all, I'm sure, have people who you're paying as independent contractors. And the goal today is to advise you of the risks of doing that and to make sure that you can either be knowledgeable of the risks that you're taking by doing that, or to reclassify them as employees. So everybody who's employing people as independent contractors, and we represent mostly very large companies. We're spending a great deal of time trying to analyze this issue for them and make sure that they are properly classifying their people. So let's talk about the two different types of people we're talking about today. Independent contractors. These are the people who are not protected by any employment laws. California has a 900-page labor code, and that entire labor code, along with the wage orders and many, many other areas of law, only applies to employees. It doesn't apply to independent contractors. And so independent contractors don't have the protections of the law that employees have. And in California, more so than any other state, we have more protections for our employees than anywhere. But those protections, none of them apply to independent contractors. So for example, whether you have to pay people minimum wage, that applies to employees. It doesn't apply to independent contractors. Whether people can file lawsuits for discrimination and harassment, those laws generally apply to employees and not independent contractors. So it makes a big difference for the person if they're an independent contractor or an employee, and for the employer as well. The taxing authorities are very, very interested in this area, primarily because if someone's an employee, you all know you have to have taxes taken out of your paycheck. If someone's an independent contractor, no taxes are taken out of that check. So that means that the taxing authorities have to wait until the quarter or the end of the year to get their money, and it's less likely they're going to get paid if they have to actually look to the person to pay it, as opposed to having it automatically withheld from their paychecks. And so the taxing authorities are very, very interested in this area because they want to be sure that they get their income taxes and their payroll taxes right away out of the check, and they don't have to rely on the person to pay it or try to collect it at the end of the year. And then independent contractors get 1099s. You often hear them as referred to as 1099 people, but they get a 1099. It's a different form than employees get. So employees, the opposite of that, they have lots of laws and rules that protect them. Payroll and income taxes are withheld from their paychecks, and they're issued a W-2, not a 1099, by you towards the person who is working for you. So as I say, who cares? Who cares that the people are misclassified as independent contractors? And lots of people care. The workers themselves care. And the classic example that everybody, I think, has followed along on this is the Uber, Lyft, DoorDash, Grubhub drivers. They are all classified as independent contractors. So when you go on your app and you order an Uber car to come to your house, the person who drives that car is an independent contractor of Uber. In fact, an independent contractor, that person's not an employee of anyone. So that means that none of the rules that apply to employees apply to that person. So employees, for example, have to have their business expenses paid by their employer. Independent contractors don't have to have their business expenses paid. So these drivers do not have to have the company that they're driving for pay their car expenses, their gas expenses, their insurance expenses, or any kind of expense. if someone's an employee, they have to be paid for every hour, whether they're working or not. And that's a little complicated, I realize, but think of it as, again, the Uber driver who logs on to the app at the beginning of the day, but doesn't get a ride for an hour or half an hour or 45 minutes. If that person was an employee, that person has to be paid the minute they log on to the app and says, I'm ready and available to take a ride. You have to pay that person for that time, even though they're not bringing in any money for you because they're not driving. And so because the employment laws would protect that person if they were an employee and say you have to pay for all the time that they're ready, willing, and able to work, even if you don't actually have work for them, if they were employees, they would get paid for that time. If they're independent contractors, they don't. So that's some of the many, many differences. Employees are entitled to meal and rest breaks during the day. Independent contractors don't get meal and rest breaks. Employees get wage statements. Independent contractors don't get wage statements. So huge differences in the laws. And that's why so many people are suing the people for whom they work, because they want these protections from the law. And if you do misclassify somebody, that person can sue you and make a claim that you should have paid my expenses and you should have given me meal and rest breaks and you should have paid me overtime. Overtime doesn't apply to independent contractors either. And you should have given me wage statements and you should have given me this and that and the other. And you didn't because I was misclassified as an independent contractor. Also, independent contractors, you don't have to provide health insurance for. You have to provide health insurance for employees. And there are other benefits that employees get that independent contractors don't. So the worker themselves can make a claim against you that you misclassified them and they, as a result, they didn't get a lot of the benefits that they should have got had they been employees. And then, of course, as I mentioned earlier, the IRS and in California, Franchise Tax Board, the EDD, can come after you and say, hey, you didn't pay, take withholding taxes out, you didn't pay Social Security taxes, you didn't pay unemployment insurance, you didn't pay workers' comp insurance for this person. And we are going to come after you and we're going to audit you. And if we find that you got this wrong, and I have represented nonprofits that this has happened to, they come in and they say, you misclassified these people and you owe us $80,000, $180,000, $580,000. And you got to come up with that money, or you're not going to stay in business. And it's very hard, as you know, to fundraise to get money to pay taxes and penalties that you owe to government authorities as opposed to helping the people that you help. So this is a major, it can be a major issue for a nonprofit. And if you do get an audit from the state, funnily enough, in California, you're more likely to get it from the state than the federal government. Please try to get counsel. These are very, very dangerous things for you to be engaged in. So sometimes workers get fired and then they go to the state and they file for unemployment insurance. And the state says, yeah, but nobody's made any unemployment contribution payments on your behalf. So you are not classified as an employee. And then the worker is upset because they don't get unemployment. And then the state is upset because they didn't collect unemployment premiums from you. And so again, the state can come after you for the fact that you weren't paying unemployment premiums for these workers. Another issue is workers' comp. Employees are protected by workers' comp, independent contractors are not. You're going to pay workers' comp premiums for your employees. You're not going to pay premiums for your injured people if they're independent contractors. So you can see that both the worker themselves would be upset that they don't get workers' comp, and then the workers' comp people are going to be upset that you weren't paying premiums. And so there's other people. And then often we find situations where workers go to a lawyer and say, hey, it's not fair I got fired. It's not fair that I didn't get paid what I should have been paid. And the lawyer might say, well, are you an employee? Show me your paychecks. And the person says, no, I wasn't an employee. I was an independent contractor. And then the lawyer might go, ding, ding, ding. That sounds like a good lawsuit. And then the lawyer may file a claim, not only on behalf of that worker, but maybe on behalf of all your workers who are misclassified as independent contractors. So I know I'm scaring you all, and that's what we're here to do, to warn you of the risks of this. So what are the penalties that you can pay if you get this wrong? As I mentioned, the taxing authorities can come after you and they can collect the taxes that you should have been withholding and the payroll taxes you should have been paying on behalf of the worker. And then, of course, there's lots of penalties on top of that. So Even if you pay back the taxes, you might have to pay penalties on top of that. As I mentioned, workers who are employees are entitled to minimum wage and entitled to overtime. Independent contractors don't get minimum wage and they don't get overtime. So if somebody says, hey, you didn't classify me properly as an employee, you have me as an independent contractor, and in fact, I worked 50 hours a week or 12 hours in a day, and you never gave me overtime. If you did misclassify the person, meaning they should have been an employee and they weren't, you owe that person overtime and attorney's fees and penalties and lots of other things. Some of the other differences between employees and independent contractors is that employees can form a union, independent contractors can't. Employees get health insurance, independent contractors don't. Employees can sue for discrimination, much harder for an independent contractor to sue for discrimination. We do have a law in California called the UNRRA Act that allows non-employees to sue, but generally the discrimination laws apply to employees. You can be liable, you can be responsible if one of your employees does something bad. They get into a car accident while they're working and they hurt and kill someone. You'll be responsible for that if they were acting in the course and scope of their employment. You are responsible for the things your employees do while they're working for you. That's the law. As opposed to an independent contractor, I'm an independent contractor to my clients, and if I go and get into a car accident, my clients are in no way responsible for the fact that I got into a car accident and hurt someone. So independent contractors, the employer, I'm using employer in quotes, the person who hires the person is not liable. If your employee does the same thing, then you would be liable. So again, that's a person who could say that the person was really an employee, not an independent contractor. And then I mentioned expense reimbursement. Again, employees get their expenses reimbursed, independent contractors don't. And so that's another difference that can lead to legal exposure. So which is better? Would you rather be an employee or an independent contractor? If you're the hiring person who's doing the hiring, then it's arguably better to hire someone as an independent contractor because you're not subject to all these rules and regulations and laws and liabilities. If you're a worker, you would think that you would much rather be an employee because you have all these protections. But the irony of all of this is so often people want to be independent contractors. And so often our clients come to us and say, we want to hire this person, we want to hire them as an employee, but they want to be an independent contractor. Is it okay if they're an independent contractor? And the answer is no. You cannot choose to be an independent contractor. You either are an independent contractor or you're not an independent contractor. The law determines that. You don't get to decide it. They don't get to decide it. So you can't waive your right to be an employee. And you can sign every single piece of paper in the world. It won't help if you are correctly classified as an employee. If you should be classified as an employee, then you're an employee regardless of what you sign. So who is an independent contractor? The example I always use is the plumber, the guy who comes to your house to fix the leaky sink. That person is a classic independent contractor. Why is that? They have their own business. They provide services to lots of different people, the community at large. They come to one house one day and another house the next day. They have very specialized skills. I don't control their work about their hours of work. For the plumber, he can work 1 hour a day or 10 hours a day or whatever. The plumber gets to decide how many hours he I should say, or she works, although I've never seen a female plumber yet. You don't get to control the hours of work. The plumber gets to decide how much to charge. If the plumber wants to charge me $100, the plumber gets to decide. I have no control on how much the plumber charges me for his work, and the plumber brings his own tools and supplies. So if you're trying to decide, is this person an independent contractor or an employee, think of the plumber. Do they have their own business? Are they providing services to others? Do they have specialized skills? Who controls the hours of work? Who controls how much they get paid? And do they have their own tools and supplies? So that's been the classic example of an independent contractor. In California, all people are presumed to be employees. And the big change in the law that we got, that we're going to talk about, is called the Dynamics case that then became AB 5. and it changed the definition of an independent contractor to what we call the ABC test. And you have to meet all of these requirements to be an independent contractor. So every day a client calls me and says, is this person an independent contractor or an employee? I say, let's go through the ABC test, because everyone's an employee unless they meet these three. So let's talk about the A, the B, and the C, or the three-pronged test. So the A test is the worker must be free from the control and direction of the hirer. So this is called the control test. Remember my plumber, I don't get to control anything about how he does his job, when he does his job. He's outside of my control. I am your lawyer. I am outside of your control. You don't control when I do it, what I do, you don't control how much I charge. I have specialized skills. I bring my own tools to the job. I am a true independent contractor. So is this person who you want to have as a worker for you, is that person free of your control? Now, obviously you have to have a little bit of control over people, but the idea is, and when you set this person up as an independent contractor, you want to be sure that this person, you have as little control over this person as possible. So don't put too many rules in place about what the person does, when they do it, how they do it, where they do it, with whom they do it, or even if they do it, as opposed to subcontracting it out to others. So that's the A test, control. The B test is the tough one, and this is the one that is getting the Ubers of the world. The worker must perform work that is outside of the usual course of the hiring entity's business. So what is your business? What do you do? And does this worker do what you do? So what does Uber do for business? Uber and Lyft and all of the others. They say we are in the business of being an app. And all we do is create an app, and our app joins riders with drivers for cars to drive for you. The drivers say, no, Uber, you are in the business of providing drivers. You're not just an app company. And so every time now you want to hire someone as an independent contractor, you need to say, is this person doing work that I am in the business of doing? Obviously, if you already have employees doing that type of business, then it's very hard to say the next person you hire who's doing the same type of job is an independent contractor. But you look back and you say, what am I in the business of doing? And is that person doing what I'm in the business of doing? And if so, you cannot meet the B test. And then the C test is, does this worker do this type of work for others? Is this the business of the worker? Just like my plumber, he's a plumber for lots of people. And the result of the C test is that the worker has to be engaged in an independently established trade, occupation, or business of the same type of work that they're doing. Is we ended up in California with tons of LLCs, limited liability companies, because people decided that they could meet the C test if they formed their own business. So instead of you hiring Melinda Reichert as your web designer, you hired Melinda Reichert Web Designing Inc., LLC. I have a different tax ID number, and people think that that helps you, and it does certainly help meet the C test, the C of the ABC test. So you don't have to be an LLC, but it sure helps if it looks like you have an independent business, it has a different name, it has a website, it has business cards. It just looks like a separate business from just being an individual worker that you hire. So every time going forward, you hire someone, you got to meet A and B and C in order for that person to be an independent contractor. All right, so what are we going to do to try and help you get through this? As I mentioned, A, control is very important. So as little control as you can have as possible over these workers, that would be good. Try not to control what they do, when they do, how they do whatever they want to do. That's good. Be wary of split years, meaning that if you issue a 1099 and a W-2 to the same person, in the same year, the IRS computers go ding, 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 and that's called a red flag. And you will be much, much, much more likely to get an audit if you have a 1099 and a W-2 to the same person in the same year. Because why did this person go from an employee to independent contractor or independent contractor to employee? Probably is not a good reason, says the taxing authorities. So I'm going to audit you and find out why you issued a W-2 and a 1099 to the same person in the same year. Rule number 3 is be very cautious about hiring independent contractors. The fewer you can hire, the much better you are. And you should be looking every time somebody hires or wants to hire an independent contractor and issue a 1099, you got to go through this due diligence to make sure that this person truly can meet the ABC test. You want to get invoices. A business issues invoices. My plumber issues invoices. Lawyers issue invoices. Independent contractors issue invoices. So try to get an invoice from the person who is your independent contractor. That makes you look much more like an independent contractor. And then be sure to have independent contractor agreements. Remember, I said just because you have an agreement doesn't make you an independent contractor, but having an agreement sure helps look like an independent contractor. So there are different types of people besides independent contractors and employees, and this is, and Jennifer will talk a little bit about this, but there's the contingent worker, and that's somebody generally you hire through a temp agency. As long as that person is an employee of someone, I'm not worried about it. So you might hire Kelly Services to provide you with a receptionist or somebody. That person will be an employee of Kelly Services. I'm not worried about it. That person is fine. As long as they're an employee of somebody, you don't have to worry about it. You will, by the way, likely have joint liability with Kelly Services for wrongdoings to that in person, particularly if they don't get paid correctly or if they get harassed on the job or their disability isn't accommodated. We call that joint employer, and Jennifer will talk a little bit about that. But that's not what I'm talking about here. Staffing agencies, contingent workers, I'm not that worried about. And then there's the professional employer organizations. Again, I'm not that worried about those people. They take care of those people are their employees. They take care of the taxes. They make sure that everything is done. But you still can have responsibility for those people. So key takeaways: evaluate your use of independent contractors regularly to comply with all the relevant statutes. And then I call it the duck test. If it sounds like a duck, looks like a duck, walks like a duck, and quacks like a duck, it's a duck. So if it looks like an employee, sounds like an employee, walks like an employee, and talks like an employee, it's an employee. And you had better be sure you comply with all the rules. And again, make sure you classify all similarly workers the same way. You can't have people doing the same job, some of whom are employees and some of whom are independent contractors. So I will turn this over to Jennifer, unless we have any group questions.
We do. We've got a lot of questions coming in.
I tried to answer as many as I could get to.
No, that's great. And let's take a few live if we can. So we have one where a person is in the process of negotiating with the grant writer, and they want to pay her as an independent contractor. So it sounds like, first of all, does that make sense? Does this person qualify as an independent contractor based on what we've learned so far? And then also had a question about this potential independent contractor wants to have their taxes taken out before they get paid. So you had said that there's independent contractor and employee. This person is asking, is there some kind of third classification?
Oh, all right. So grant writer, A, are they free from your control? Yes, please don't control them. Let them write the grants. You can say, hey, I'd really like you to write a grant for me and get me as much money as you can. You can even say, why don't you try this foundation and that foundation? But don't say, here's how you write it. I want the first paragraph to say this, the second paragraph to say that. So the least control you can exercise would be good. B, are they in the business of doing what you're in the business of doing? I hope you guys are not in the business of writing grants. You are in the business of helping serve needy people. But you need to have grant writers. You need to raise money, but you're not in the business of writing grants. So I think you meet the B test. And C, Again, as long as this person is writing grants for others, is in the business of writing grants, if they have an LLC, I am the grant writer extraordinaire LLC, then you're likely to pass the C test. So I think grant writers are very low risk.
Great, thank you.
And
Okay.
by the way, there is no mid ground. You're either an independent contractor or an employee.
Great.
Tell the person to set up a bank account and be disciplined enough to take the taxes out of the check and put it in a separate secret account that they can't touch, and then make quarterly tax payments. You can make tax payments as often as you want as an independent contractor. I'm sure the government would love you to have your tax payments every day, but you must do it quarterly, and obviously you have to do it more frequently if you make too much money, but you cannot take taxes out of an independent contractor's check.
Okay, great. And you're one or the other. Okay,
Yes.
wonderful. We have some concerns about the penalties, which I know was part of why you shared that information with people. How far back can the penalties go? Like if, for example, somebody's been an independent contractor for 5 years and all of a sudden, they realize that now they need to be reclassified. How far back can the penalties go?
All right, so tax penalties, I'm not a tax lawyer, but I think it's like 3 years, but I'm not, if you file the tax return, I think it's 3 years. Labor code is generally 4 years. Forming unions, don't worry about it. Discrimination laws used to be 1 year, it's now 3 years. Torts, generally 1 year. Expense reimbursement is 4 years. So each rule that you violate has its own statute of limitations that says how far back you can go.
But AB 5 is not retroactive, right? So it would only go back as far as when AB 5 became effective. Is that right?
Except if they were misclassified. So the AB 5
before,
yes, adopted the dynamics test. The dynamics test was in 2019, and dynamics. Are we saying, Jennifer, that dynamics is retroactive or not? I believe it's retroactive.
It's not entirely clear, but I think California courts are going to say it was retroactive. The decision suggests it was retroactive. Whether that's fair is a different question. But
right, so it declared what the law has always been, according to it. Dynamics decision says this has always been the law. I don't know why you guys didn't understand that we've always had the ABC test in California, even though there's not a single case anywhere in the history of mankind that said we had the ABC test in California. But the court gets to decide if it's retroactive and declaratory of existing law, or whether it's new law. And if it's new law, then it's not retroactive.
Okay. And people have particular interest and concern around the B part of the test. And I know we're going to get into the ABC test a little more.
Talk to my friends at Uber. They have a lot of concerns about the B part.
And, without getting into the case law in any great detail, is there any particular example you can give that might further clarify the B part?
No, I mean, again, you have to think what I'm in the business of doing. So you're not in the business of being a plumber or a grant writer or a window washer or security guards or those types of people. So I think those people are, would not meet they're not in the business of doing. So you might be able to get them under the B test. So it gets to be a little more confusing. As I say, a web designer, I don't think you're in the business of doing that. It's hard without specific examples to think of, but believe me, Jennifer and I are advising clients every day about whether they meet the B part of the B test. And you can see
and it's not that we're not going into the very helpful cases. There aren't a lot of very helpful.
There are no cases.
Okay.
Since this is new law.
It's not that we're just saying, oh, that's too legalistic. Like I'm holding them in my hands. You can see them. So it is very tricky. And I think it is particularly tricky for more complicated companies, right? Which even, small nonprofits can still be complicated. If you do one thing, you make widgets, well then great, you're a widget maker. Is it part of widget making? But most businesses are not that complicated, especially if you're providing, services, a variety of type of services to various groups in need. You probably do a lot of different things. You do what you can. So what your actual business is difficult. I'll give you an example. There were some cases in the insurance industry where the question was, what are they in the business of? And the plaintiff said selling insurance. Paying claims, and insurance companies said, peace of mind. It just, and then certainly all the gig companies, as they're fondly or not so fondly called, same thing. Are they technology companies? Are they driving companies? Are they delivery companies? lots of fights without a lot of answers. So it is frustratingly difficult. So if you're thinking, gosh, why aren't we just telling you the answer? Why are we hiding the, the lists of contractors and employees? It's because it's all very much, in the process of being thought about and decided. And the reality is litigation is costly and expensive. And so even claims that are brought often don't result in any sort of opinion. They're settled in some way or resolved in some way. So we're left trying to struggle with the pretty tough to apply test.
Great, thank you. And we have a lot of questions about particular people in the arts, but I think I want to let you all give some more information first. But we also have some questions about people who are independent contractors, but also primary volunteers running the nonprofit. Where do you land on something like that?
So a lot of the employment laws don't apply to volunteers. They don't have to get paid. They don't get minimum wage. They don't get overtime. They don't get wage table. All of those don't apply to employees, to volunteers. And I have a whole lot of rules on volunteers. But generally, you cannot volunteer. It's harder to volunteer for the company that you work for. So if you are working for a company, you can't say, oh, after 8 hours, I'm going to continue to work, and now I'm a volunteer. That doesn't work. You've got to. There's a big distinction between working for a company and then volunteering. If someone's just a volunteer, then I'm fine with that. But they can't switch between working and volunteering for the same organization.
Okay, great. Thank you. Well, I think we should keep going because a lot of the questions people are asking, I think your information will answer, but we'll take more questions as we go. So thank you.
Very good. So how did we get here? Many question marks. It probably feels like everyone is talking about independent contractor status. And has been basically since Dynamics came out, and then AB5, and there's been follow-ups to AB5 and Prop 22. It seems like it's all independent contractor all the time, especially for those of you who have an HR role and get updates from HR organizations, lawyers, and the like. It is a hot topic, but it isn't really a new one. There has been a sort of a long-standing debate as to whether someone is an employee or a contractor. What has sort of brought it to the forefront are two things. One, Dynamics acting like we all knew the ABC test was in place, which of course we did not. And just the reality of wage and hour litigation becoming more and more common. In the 80s and 90s, you didn't see wage and hour class actions. It wasn't until 99, 2000, 2001 where you started to see the first hints of wage and hour cases, and then there was the explosion of wage and hour class actions and PAGA cases, which we won't even try to touch on today, private attorney general act cases that are a type of representative action to seek penalties on behalf of the state. So that's shined a spotlight on anything wage and hour related, because as plaintiffs would want to file wage and hour cases, and we're told, oh, no, these are not employees covered by those wage and hour laws, these are contractors, then the whole challenging, are they really, I think kind of got pushed to the forefront. So as Melinda alluded to earlier, there really are three types of categories of workers. There are employees, which there's all sorts of employees. We'll get to that: part-time, full-time, seasonal, temporary, et cetera, but employees. Then there is the independent contractor. And then the third category, which is really kind of just the first category, but a little more complicated, is joint employees. So some of the categories Melinda referenced earlier, like it's a temp agency. And so where the person is placed and the staffing agency might be on the hook for employment, or shared employees, all sorts of versions where you're at least somebody's employee, but arguably more than one. So we'll move on from there. So this case is the Dynamics case. I have to confess, for about the first year at least after this case came out, I called it Dynamics. And then finally someone said, which makes no sense, right? Dynamics is kind of a weird name. And at some point someone said, I think it's Dynamics. And Melinda will laugh at me. At one point, I'm like, I got to know for sure. This is a case we're all going to be talking about. I got to know how to say it. I Googled the company. I called. I'm like, I can't wait until they answer the phone, or even if it's a recording, I don't care. I'm going to hear them say their name, and I'm going to know I'm right, and I can hold my head high. Well, the company changed its name. So however you want to say it, I say that, to each his, her, their own. So Melinda alluded to this earlier. This was sort of the earth-shattering seismic event that happened in wage and hour law. And it's important to us because of all the bolding and underlining. We did stick with the normal litigator's rule that you can only pick 2 forms of emphasis. It's not bolded, underlined, italicized, and all caps. But if we could, we would, because it was that big of a change, which basically said that all workers are employees, basically, unless the hiring entity, the would-be employer, can prove otherwise. And it's your burden. And chances are, if the issue has come up and you're having to fight it, it's going to be a bit of an uphill burden. And so these are the 3 factors, the ABC test that Melinda covered before. We're going to talk about each of them individually a bit again. Prong A. This is sort of the old test in my view. This is sort of what we looked at before, often called the Borello test, which is a multi-factor test. The IRS has a 20-factor test. There are a variety of tests that were out there. And this prong A is kind of what we used to look at, the degree of control, sort of the economic realities of the relationship. And it's clear that the worker, in order to fit this prong A, the plan, the contract, the contemplation is that this should be a job that's free of control and that actually happens in fact. So to go to the grant writer, because that's a good, simple example to have in our context, probably better than the plumber example, is that you hire someone to write the grant using their expertise, and then you actually let them do it. Now, that doesn't mean you can have no involvement at all in the ultimate product, especially if it's your name that's going to be on it. But it truly is, you're hiring someone for, I always think of it as sort of an end goal, not for how they do it, but for where they go. And it doesn't have to be, every little thing that is controlled in order to count as control. Where that line actually is going to be much litigated, but the less control, the better in order to support independent contractor status. So that's prong A. Prong B, as Melinda said, is a tough one because, in order to apply it, you have to be able to define the usual course of the hiring entity's business. And for some organizations, it's pretty straightforward. You have a pretty straightforward mission, and what you do is pretty narrow, et cetera, so you can sort of apply this. But for, I would say, most companies, profit or not for profit, it can be more difficult to apply. So courts have suggested some standards, and Dynamics suggested some standards. They will look at, and again, I think some of this is true of the old test. They'll look at, how do you hold yourself out to the public? What does it say on your website, in your mission statement? Maybe in those grant proposals that we talked about. How do you describe your business to the outside world? Maybe even in, job postings and things like that when you're filling employment positions. Some other sort of things that are not necessarily determinative, but certainly a blinking red light for anyone applying this analysis, particularly a court, is if you have your contractor or would-be contractor doing basically the same thing or similar thing as employees, you're probably not going to be able to satisfy prong B. And I will tell you that's often the question when I say, well, do your employees do this too? That really shifts the analysis when we're walking through this with folks, because I think a lot of entities have employees that sort of do the core work and have used contractors to kind of fill in the blanks, right? Where you have a surge of activity, for example. And so really what those folks aren't contractors. They're just short-term employees or types of employees that don't have a guaranteed amount of hours or things like that. They're not really independent contractors. So that's something important to take a look at. And if something is kind of critical to your business, it doesn't mean it is your business. So the idea is to look at whether it is key, whether it's common, normal, regular versus sporadic. And again, those are all terms that we could fight about. And you would if you were in court or dealing with an agency on this, but at least it gives us some standard. Moving on to C. So C is whether or not the worker, this looks at what the worker actually does, whether the person is in an independently established trade, occupation, business of the same nature involved in the work. And courts will look at the worker's ability to provide the same services or related services to others, and whether or not they actually do. In the old days, we would see, employers insisting that someone, for example, had their own business cards, or they would look for people having like an LLC set up or something like that to say, look, they have their own business, they're free to do it for other people, that supports independent contractor status. But courts will look a little deeper here to make sure whether that really is a reality, whether that's something that sort of makes sense as an independent contractor and actually works that way in practice. The person is able to work for others. That can be difficult when you have people in a would-be independent contractor role who, for at least a period of time, would have access to confidential information, or they really couldn't provide the same service to a competitor. Less of an issue probably in the nonprofits, but that's where that factor can become a little dicey. So AB5 was the sort of second seismic event here. So Dynamics came out in 2019, 2018, what was it, 2019. And that was enough of a shockwave. And our California legislature said, we like it, and basically said, we're codifying this test and making sure that it's clear that it really is the test for the California standard generally for anything for which the employment relationship is relevant. So not just certain wage and hour provisions of the labor code or the Industrial Welfare Commission wage orders that essentially provide some of these wage and hour standards, but that more broadly, it's the wage orders, it's the labor code, it's the unemployment insurance code, which relates to unemployment benefits and the like. It's the standard in California. One thing that AB5 did not seem to impact is joint employment. And the way I always think of this is the concern when you read the legislative history and the discussions that were going around the passage of AB5, Assembly Bill 5, was that the concern was that people not be deprived of the rights and benefits of employment status. So I don't think the case law, and definitely not the statute, were really motivated to mess with employment so long as you're somebody's employee. So that's why even if you have a joint employment situation or a situation where you don't think you're the employer, but you might be, as long as it's someone's employee, the person is someone's employee, so they're paying taxes, they're getting access to unemployment and other state benefits, workers' comp, all of those things, it's less likely to be an issue. So if you're the person you're looking at as someone's employer, you have less to worry about. So what to do other than decide to turn off your computer and find something else to think about for the day? Look at your independent contractors. I think sometimes people have been classified a certain way historically out of habit, or, someone 3-4 people ago in your job agreed to do it that way. And so you really do want to look, where do you have your 1099s, and apply the ABC test. Hopefully you'll find that the ones you want to have as contractors, and that's a good fit, that you have at least a really good chance of being able to defend that classification, even if it's not perfect, because it's hard to truly know the for sure answer, and assess it. And again, get legal advice. Don't create a bunch of memos and emails and documents sort of hashing out your analysis. Because those are going to be discoverable, and you want to be able to take a hard look at the classification and kind of have the pros and cons, right? Look at a position and say, well, this is good, but I could see an argument that this. So, keep it out of documents and get some legal advice, not just to help you make the right decision, but also to help shield some of those communications so you can really be sort of candid and thorough about your evaluation. So if you do all those things and you apply the ABC test and you think this is never going to work, this person is misclassified, or if we get challenged, I think we're going to have a really hard time proving independent contractor status, what do? First, consider making them employees. As we've both alluded to before, having someone as an employee doesn't mean full-time status, doesn't mean 40 hours a week, doesn't mean guaranteed employment for some period of time. Employees, unless you decide otherwise and designate otherwise, are at will. You can have people for whom you don't guarantee a certain number of hours. You can have, part-time, per diem, all sorts of varieties. And someone could be hired for a day, for an hour, theoretically. So for any, finite period of time. Now you have to watch out for other rules like final pay rules and payday rules and things like that. So you have to comply with all the wage and hour rules. But look and see whether this person isn't really an independent contractor, but really they're just a different type of employee. And then, look at the cost. Figure out, okay, so this is what it's going to cost us now. If I'm going to treat someone as an employee, is this a salaried position? Is it an hourly position? What's the right rate, to be competitive, to make this person happy and keep them, but something the organization can actually do, and, look at the whole picture. And even though the costs may seem like they're adding up, it might still be the right thing to do given the potential costs of getting it wrong. I would say consider redefining the job. Sometimes you have someone as a contractor and you think, boy, I'm just not sure how to be able to defend this, even though it seems like it is a good fit for contractor status. Take another look at what that person could do for the organization. It can also help when you're reclassifying someone to not have to say, we think we were wrong before, but to say, we have some new thoughts about the way your role is going to go, or what role might be the best fit for you. And so it really kind of is a new job, so to speak, that you're hiring that person into. You can consider hiring workers outside of California. Sad but true. Lots of businesses, it's well covered in the news, have chosen to leave California when they can. Certainly with organizations like call centers, warehouses, offices where the employees could be elsewhere. It's one thing if you've got a retail store, right? You need to have a brick and mortar where people are walking in, or a hospital. Things like that, their physical location are important. For other jobs, I think we've all learned this, particularly during the pandemic, that can be done remotely and from anywhere. Maybe California isn't where you want to be. Sorry to say it. You could move everyone to another state or just certain workers. This is Melinda's. I will give her credit. You can hire robots. The California Labor Code defines employee, and it does, I think, if I remember correctly, use the word person. So our legislature hasn't quite figured out how to bring robots under the Labor Code. We're half kidding, of course, but there you go. And you can try to lobby. As you will see when Melinda gets to some of the exceptions to AB5, it's messy. There are a lot of them. Some of them are really hard to understand. I mean, I can read it several times. I know the meaning of all of those words in the English language, but when you put them together, I have a hard time knowing what the heck that means. So, but there has been a lot of success. So it might be that doing some joint efforts could get an exception, or at least something that would help you in being able to have the law work for you. So if you are going to reclassify someone, as I said, there are some ways to do it. You can redefine the role, basically hire them into a job that's not exactly the same. Beginning of the year is a great time to do it. As Melinda said, the IRS is more likely to note the flag of the 1099 and the W-2 in the same year. So it's nice to have someone treated consistently for a whole tax year. And it's also just kind of a appropriate time for new things, right? New year, new job. The tricky thing comes when if someone questions you about, well, if you're calling me an employee now, wasn't I an employee before? And, don't you owe me money for that time? I think, that's how you answer those questions, and whether you decide to actually sort of settle up with people is complicated and nuanced, and you would definitely talk it through with a lawyer. Part of it will depend on just the realities of what you can do financially. But there are ways to deal with that communication. And in cases where you really do want to sort of square up with the employee, you could consider some kind of settlement or payment or something like that. Now, of course, that's not going to resolve any issues that any agency could have with you, like taxing agencies. It would purely be a resolution with that individual.
Great, thank you, Jennifer. We have a lot of questions, but I think some of the
I saw the flashing to the side.
Yeah, I think the AB 2257 exemptions, and you talking about that test, I think is going to help some. But so I want to ask some questions based on the information you all have already shared. And Annie, please jump in with questions as well. So if a person had misqualified, misclassified an employee as an independent contractor and then corrected it, are there still concerns about the time that they were still an independent contractor?
Sure. Yeah,
Yes.
I mean, the
Okay.
agencies could still have issues with unpaid taxes. You know, so someone could go to the workers' comp appeals board and say, I really was an employee, I should have been covered. You know, could file a lawsuit saying, hey, I didn't get my meal breaks, therefore I'm entitled to the penalty that goes along with that. So unless you've done something to resolve with the employee / contractor, everything remains, and you just kind of have to cross your fingers as the statutes of limitations tick by.
Okay, great. And people are asking about calendar year versus fiscal year for making that change. It sounds like the sooner the better, and we've got an end of calendar year coming up. Is that your assessment?
Right.
Okay.
For the risk of
taxing
potential
authorities-
liability and flagging.
Yeah, the taxing authorities work on calendar year, not fiscal year.
Right. Okay, great. I think it would be good for you to continue to share the information you have. I think it's going to answer a lot of the questions we have about the exemptions and what you do if you think a potential employee / independent contractor fits within one of those exemptions.
I'm just going to touch briefly on Prop 22. It does not solve any of your problems unless you have app-based drivers or $200 million, whichever. Prop 22 does not help you. It was put forth by the app driver companies, and it benefited only the app driver companies, and I don't think it's going to help anyone else. AB 2257, now that is a game change, because here came the lobbyists, and the legislature had passed AB 5, and then everybody said, oh, but it shouldn't apply to me, it shouldn't apply to me, and the lobbyists all came in, and 50 different industries, freelance positions in 15 different other industries all got exempted, and I'll briefly go through them. But don't think just because you have an exemption that you are scot-free. And I'm not going to spend much time on the Borello factors, but Borello was kind of the old law before dynamics. Now you've got me doing it wrong. So, and the dynamics, the Borello factors is essentially a control test. It's got lots of different factors, but I think of control as being the most important. But just because you come within one of the exemptions that are in this statute of 2257, you are not scot-free. You still have to meet the pre-dynamics law, which is the Borello law. And as you see here, control is the key. And then I've listed here all the things that look to control, you know, the different things that might make up control, but just keep control to a minimum, and then you can try and avoid all of these Borello factors. As you can see, there's lots of Borello factors, page after page after page of Borello factors. So the exemptions, I'm going to very briefly go through these, but there are certain people with professional licenses that are exempt. Of course, the lawyers are all here too, and accountants, architects, engineers, private investigators, real estate agents, all of the hairstylists. Those people who have licenses, they are exempt from AB 5, exempt from dynamics, but they're still subject to Borello. So control test. Now, I'm not going to go through all of these, but I started to make a list of the jobs that are exempt. And I ran out. So here, ran out of room. So writers, artists, photojournalists, editors, newspaper cartoonists, translators. Again, these were the lobbyists who came in and said, you can't possibly make this law subject to me. And they agreed. Whatever a cartographer is, I don't even know that we have map writers anymore, but they are exempt too. But wait, there's more. Musicians, insurance agents, real estate people, manufactured house salespeople, youth sports coaches, landscape architects, professional foresters. But wait, there is more. Travel agents, marketing professionals, human resources administrators, graphic designers, grant writers, there you go, enrolled agents, payment processing agents, competition judges, and anyway, goes on and on and on. These people are exempt from AB 5, they're exempt from the dynamics ABC test, they are primarily subject to the Borello test of control. Then in addition to all of those people who are exempt, there are various other types of exemptions. And the one that people keep hoping, so these are the different types of exemptions, and I'm not going to go through all of them, but people keep hoping that business to business exemption is going to help them. First of all, you still have to meet Borello, and you've got to meet all of these things, every one of these things, in order to come within the business to business exemption. And it's really, really, really hard to come within all of those things. So look, I don't know if you're going to get the slides afterwards, but look at all these factors and don't think you, just because you're doing business with a business, that you come within the business to business exemption. You probably don't.
Thanks, Melinda. Yes, everybody will get the slides as well as a link to the recording. So can you just very briefly, I mean, what you're saying is that even if you think that an independent contractor fits within the exemptions of this new law, they still have to meet this Borello test. Can you just in 1 or 2 sentences say what the difference is between the ABC and the Borello?
So remember the B and the C of the ABC test. Are they in the business of doing what you're in the business of doing, and are they do they have their own independent business? Those are the B and the C of the ABC test. Borello was much more of the A of the ABC test, the right to control. So are they required to follow instructions? Are they supervised? Do they attend company training? Do they have certain work hours that they have to work? Are they on the company's premises? Do they have to do things in a certain order? These are the things that was the old law, the indicia of control. So what you want to try and do is get back to this Borello if you come within one of the exemptions, but you still need to make sure you're not controlling these people, that they can do what they want, when they want, how they want, with certain exemptions. And the length of time is a factor. If you have someone working for you for 3 years full time, that looks like an employee. If you provide the tools, the laptops, the computers, then that looks like an employee. If it's unskilled work, that looks like an employee. If it's payment by the job, I will pay you $100 to fix something. That looks like an independent contractor. I will pay you $10 an hour. That looks like an employee. So there's no one factor that's key other than control, but these are the different things that we look at to decide if, in fact, you have control under the Borello.
People are asking a lot of questions about stipends and honoraria. It sounds like they might lean towards an independent contractor, but maybe, I don't know whether you need more information or if you can answer, like for $20 per performance for choir members, or honorarium for participating in focus groups, or that kind of thing.
Yeah. So again, if you meet the ABC test, then that's fine. If not, they're employees and you can't pay them $20 for a performance because you've got to pay them for every hour they work. It has to be minimum wage and all of that stuff.
So you still have to go through that.
Those people are the people that were hurt the most. I mean, they really were hurt, these orchestras. I don't know if anybody reads Willie Brown in the Chronicle. He's one of my favorite commentators. The old rule was that you could only submit 35 articles to a newspaper and be an independent contractor. If you submitted 36 articles to a newspaper, you were an employee. So after 35 articles, he stopped writing, and his column just went away. And then as soon as they passed an exemption that covered him, he went back to writing articles again. That's how stupid this was, and how they defined it and then redefined it with the AB 2257.
Okay. And then we have a lot of questions about tutors, part-time teachers teaching online. Did I see a tutor exemption?
No, you did not see a tutor exemption.
No? Okay.
Nope.
Master
Nope,
teacher.
sorry. Yes,
Okay.
so teachers are, in my view, almost certainly employees.
Okay.
And particularly if you're in the business of teaching, but it's pretty hard to say that, a tutor, I don't know if you're in the business of tutoring, then you're not going to meet the B of the B test, but you might get with an A or C if someone's in the business of tutoring. It's so much easier to make them employees if you can afford to do so. And, you don't have to provide benefits to people who are really short-term employees, who don't work many hours, I'm sorry. So I just tell our clients, try to make them employees if you can. I realize it's a little more expensive to do that.
Okay. And then we also have a lot of questions around the fact that many people in the arts really want to stay independent contractors because they like having the flexibility to be creative in the ways they want to be creative. But I believe you said earlier that it isn't actually up to the independent contractor / employee. Is that correct?
Correct. And you can be creative as an employee too. So just tell them that they can be equally creative as an employee. So here's some of the other exemptions. You can see there's a referral agency and the professional services. But we're going to get to the musicians and musical groups. They have their own exemption. But look at how many things you have to meet to come within this exemption. So not all musicians are exempt. You have to meet all of these things: a symphony orchestra, a musical group at a theme park or an amusement park, or a musician, and you have to do all of these things to come within it. Marketing people, still subject to Borello, but you still have to meet all of these requirements to vocalists are covered, and independent radio promoters, photographers, record producers, managers, songwriters. So they got themselves an exemption with their lobbyists. But you still have to make Borello for all of these people. So here's some more on musicians and vocalists. They get their own exemption, but you have to meet all of these things to get within the exemption. Construction subcontractors, they got to meet all of these things. Construction trucking, they have their own. Data aggregators, they have their own. Direct sales, they have their own. So there's lots of different exemptions, but each one has so many requirements. You've got to make sure you can meet every one of them.
Okay, great. And there were some questions about how these different categories are defined, and in some cases, the law provides more information about that.
Yes,
right?
definitely.
Okay.
So if
Good.
you want to come within the musician exemption or the vocalist exemption, go to the law. You can look at this slide and you can see, am I going to meet all of these requirements to come within the musician exemption?
Great. Annie, any burning?
Yeah, I want to say first that I put a link to a publication that we have about legal issues for volunteers, because it does talk about that stipend issue if you're wondering if somebody is a volunteer or an employee. And then I going back to the business to business exception, my question is, what do you do if you don't meet that exception and the person that you want to hire is an LLC or a corporation? Do you say we can't hire you as the LLC, because I'm assuming you can't make an LLC an employee, so then you go in and hire the individual? I mean, what is the upshot?
Yeah, you should hire the individual. They can have their own LLC on the side, and if they, some people found out when they applied for for unemployment insurance that one company made them an employee during the year, and for everybody else, they were an independent contractor. And that really hurt them when they applied for unemployment benefits because they couldn't get one or the other. So some companies are really strict in hiring people as employees, and other companies are less strict and hiring them as independent contractors. And you could do exactly the same work for two different companies and be an employee for one and an independent contractor for the other. And that was not legal, and it turned out to be a big problem.
Okay, well, I'm seeing that we are almost out of time. So let's move on to some of our closing slides. And this is not a closed book. We had AB 2257 this year, and you talked about lobbyists participating in shaping that law. No doubt there will be additional efforts to create further carve-outs. So the conversation will continue. And just one more reminder that we will get the link to the recording and slides to you with some additional resources as well in the next couple of days. So I want to remind our not yet members that you can join Cal Nonprofits, and here are some great reasons why it would be good for you to join. I also want to extend a big thank you to Annie for our partnership with Public Counsel, and to Melinda and Jennifer for sharing their amazing expertise with us today. And last but definitely not least, I want to thank our tech team today, Christina Dragonetti and Christine Metropolis. Again, you will get the recording and the slides and some additional resources. Have a great day, everybody, and thanks again.